meeting of the Blowing Rock Board of Adjustment to order. I need these Springs. I'm the chair. This is Mr. Jerry Starnes, Mr. Stephen Schiller. To my left is Ms. Sarah Murphy and Mr. Brandon Walker. I thought we were going to elect officers tonight, but we are not. The Blowing Rock Code says we're to elect our officers once a year. The only officers we have is the chair and the vice chair. And Mr. Rothrock educated me that new members are a chair and vice chairperson selected once new members are installed in March. And the current chair serves through that meeting in February if there is one. So we'll wait till the new board members come on, if any, and we'll do it in March. Does that sound right, Mr. Rothrock?
Sounds right. Yes, sir.
And speaking of time, one of our local rules is that if this is still going on at 8:30, we will stop and decide if we can be through by 9:30. If we're not confident we're going to be through at 9:30, we'll pick a continuance date at 8:30 and we'll leave then. Yeah, the goal is to never be here past 9:30. So keep your eye on the clock. If it hits 8:30 and I don't say anything, somebody pipe up and say, let's talk about the time. First thing we need to do is approve some minutes from our October 23rd, 2025 meeting. Have all members of the board received a copy of those minutes? Does anyone see any errors or omissions in them? I did not. Everyone shaking their hand, no. Do I hear a motion to accept the minutes from the October 23rd, 2025 meeting?
We accept them.
Mr. Starnes makes that motion. I second it. All in favor of approving the October 23rd, 2025 minutes as written, say aye. Aye. And they are accepted, and we'll move on. I had printed the North Carolina Court of Appeals case, Chad Frazier versus Town of Blowing Rock. I had a copy of the case printed for every board member and some notes I wanted to go over. Did everybody get a copy of that? And this is strictly for the board's edification. Some members of the public, just be patient with us. This is the only time we get together. In the Frazier versus Town of Blowing Rock case before the North Carolina Court of Appeals, the court went over the history of the town's attempts to regulate temporary rentals, which started in 1984. You see that history described in the factual and procedural background section of the case, of the Frazier case. Later in the case, in the analysis section, starting on page 7, the court made various conclusions and statements of law, including, on page 8, the free use of property is favored in our state. Next, zoning ordinances are in derogation of the right of private property, and where exemptions appear in favor of the property owner, they must be liberally construed in favor of such owner. That was on page 8 of the case. Because zoning regulations are in derogation of common law rights, they cannot be construed to include or exclude by implication that which is not clearly their express terms. The next one says, when there is ambiguity in a zoning regulation, there's a special rule of construction requiring the ambiguous language to be construed in favor of the free use of property. Well-founded doubts as to the meaning of obscure provisions of a zoning ordinance should be resolved in favor of the free use of property. Our jurisprudence is clear that in the event of doubts or ambiguity, zoning regulations are to be construed in favor of the free use of property. The Court of Appeals agreed with the Superior Court judge who heard the case when it was appealed over to the Superior Court in Boone, when he said ambiguity can leave regulation in a state of uncertainty, which in turn left the rights of landowners to the unguided discretion of the Board of Adjustment. That hurt. The town started properly regulating short-term rentals of less than 28 days for the first time on August 13th, 2019. The town's ordinances existing prior to, and this is me talking, this is no longer the Court of Appeals. The town's ordinances existing prior to August 13th, 2019 did not properly regulate, I'm sorry, this is the Court of Appeals, did not properly regulate short-term rentals of less than 28 days. I noted there's a typographical error on page 11 of the case regarding the date of enactment of that new effective short-term rental ordinance. The date, August 19th, 2019, in the first sentence of that last paragraph, that's a type. The date is August 13th, 2019. The Court of Appeals then said short-term rentals were not regulated by the town until the 2019 amendment, August 13th. They noted the burden of proving the existence of an operation in violation of local town ordinance, zoning ordinance, is on the town. Ordinarily, once the town meets its burden to establish the existence of a current zoning violation, the burden of proof shifts to the landowner to establish the existence of a legal non-conforming use or other affirmative defense. The defendant, of course, has the burden of establishing all affirmative defenses, whether they relate to the whole case or only to certain issues in the case. As to such defenses, he has the laboring, or the city had the burden of proving the existence of an operation in violation of its zoning ordinance. The case tonight is not about a violation. It's about trying to establish short-term rentals. It's not a violation. We're not hearing a violation. The Court of Appeals noticed that Section 16-2.2 of the Blowing Rock Land Use Ordinance defines a non-conforming use as a non-conforming situation that occurs when the property is used for a purpose or in a manner made unlawful by the use regulations applicable to the district, the zoning district in which the property is located. Referring to sections 16-8.1 and 16-8.6 of the land use ordinances, the court continued, non-conforming situations that were otherwise lawful on the effective date of this chapter may be continued, provided the grandfathered non-conforming use is not discontinued for a consecutive period of 180 days or discontinued for any period of time without a present intention to reinstate the non-conforming use. That was on page 16 of the Frazier case. The court concluded that the effective date of the chapter was 13 August 2019, and since the time when Frazier bought the property on 29 June 2016, there had been no 180-day period he did not rent a unit for less than 28 days. The violation notice that Frazier received from the town was dated 13 September 2019. The court concluded that Frazier had made out a prima facie case of non-conforming use under the town's ordinances. The court further concluded that Frazier succeeded in his claim of grandfather non-conforming use when the court said the Board of Adjustment's denial of Frazier's claim of grandfather non-conforming use was incorrect. So to kind of summarize that case, Frazier buys the property in question on 29 June 2016. Since that time, there had been no period of 180 days when Frazier had not rented the property for less than 28 days. He was actively renting it. Almost 3 years goes by when Blowing Rock enacts short-term rental restrictions on 13 August 2019. Up until that day, Blowing Rock has not had an effective short-term rental regulation ordinance, so Frazier's use could be said to be conforming or legal conforming. So there was no law about short-term rentals until August 13th, 2019. So he was entitled to do it. There was no law against it. On that day, 13 August 2019, his use became legal non-conforming because he's grandfathered. And since his purchase of the property in 2016, there's been no period of 180 days when he didn't do a rental of less than 28 days. Private property rights obviously are very, very important in the United States and in the state of North Carolina, and the courts jealously defend those private property rights. So basically, I think what we've learned from this is the ordinance in question has to be clear, has to be understandable, can't be ambiguous. And if it is ambiguous or hard to understand, we can't guess at it. Unfortunately, ordinances aren't always as clear and unambiguous as we would like, but we got to take the law as it comes to us. And in the close calls, the landowner wins. Anybody got any questions? All right, let's move past that. And turn to the appeal we have scheduled for tonight. And let me find my checklist. All right, Stephen, what'd you do with it? What are you looking for? My checklist. Let me see if I've got another one. It was here a minute ago. All right, this is here it is, case number 2025-01. The applicant or the appellant is Rock Pine Rentals LLC. And wait a minute. Put that over there. The minutes will be kept by Miss Wanyu over here. And I noticed that the person that signed the application or signed the appeal notice is Mr. Chad Hollister. Is Mr. Hollister here?
Yes.
And it looks like you filed and signed the appeal on November 20th, 2025, Mr. Hollister.
The appeal?
The date that you signed the appeal notice or the appeal.
That's what it says, and yes, I can look at it real quick.
Okay.
That sounds about right, though.
Okay, all right. The applicant is Rock Pine Rentals LLC, and the authorized representative is Chad Hollister. Is that correct?
Yes.
Okay. Did you receive a copy of the staff report prior to tonight?
Yes.
Okay. Did all the board members get a copy of the staff report before tonight?
Yes.
Okay, all right. I went through it when I got it. The purpose of the staff report is to kind of get us up to speed on what this is about so that we can kind of get prepared, the board members get prepared and know what the issues are and research those and know what ordinances and law is involved. I went through it and I got a little bit confused because at one point in here, you said you were the owner of the property. Are you? And then at another point in here, I think it was James Hollister said he owned the property. Who owns the property?
Rock Pine Reynolds LLC owns the property.
Okay, who owns Rock Pine Reynolds LLC?
My father, James.
Okay,
So there might be a typo or something. I manage the property.
okay. Are you a licensed attorney at law, Mr. Hollister?
No,
Mr. Hollister, well, let me stop. Is there anyone here that feels like they should be a party to this case? Anyone here that feels like they should be a party?
Yes.
Ms. Garrett?
My name is Chelsea Garrett. I'm here with my law partner, Brian Martin from Gil Mosley Law Firm, and we do represent several owners who would like to intervene in this hearing if it goes forward tonight.
Well, it's gonna go forward. Let's take them one by one and let's see if they meet the requirements for standing.
So, I actually do have one preliminary matter I would like to ask, and that is, I could not find a copy of any rules of procedure or anything that the board had adopted online. I might have overlooked them. But I was under the impression that there were rules,
Just a few.
okay, and that one of them pertained to affidavits.
Yes,
Okay,
yes.
okay.
Are you familiar with the wording of that?
I vaguely recall that being an issue in a prior hearing years ago, that was a fairly new rule, and so I just wanted to hear about it.
Right. I think I've got a copy of it right here.
It's number 3.
And are they online, Mr. Petrak?
We're working on that. I don't know if
That's fine.
that's.
I don't mind that they aren't. I
They-
just hope I didn't overlook them. That was all.
They-
So,
No, they're available to the public, but I think we're belated in getting them online.
I didn't think to ask for them before tonight, so that's my fault.
Sworn affidavits. This is a rule we adopted back in 2021. Sworn affidavits, introduction of sworn written affidavits into the record of a board hearing where the affiant of the statement is unavailable for cross-examination under oath or affirmation, and where no hearsay exception for admissibility under the North Carolina Rules of Evidence exists, is discouraged as incompetent evidence. Any introduction into the record of such hearsay evidence shall be at the sole discretion of the board. That's the rule.
With that, I guess before I really say anything else about that, we should go ahead and I'll bring up one witness at a time for intervention and see if the board approves.
Good.
Ms. Garrett, do you want to review the rules of procedure for the board prior to doing this motion or anything further?
It might be good for me to look at them just to make sure, and also for Mr. Hollister to see them.
He does.
Does he have
already
one?
have a copy?
Okay.
He should have already received a copy earlier.
Okay,
I have it pulled up here. I don't have a printed copy.
Okay.
so much, but you wanna look at it real quick on.
Sure, or
mine?
if you wanna email it, I think I have.
Yeah,
it.
that's fine, I'll
Okay,
just.
would that be
forward it to
okay? Thank you.
Well, if it's gonna speed things up, I'll hand you written copies. How about
you.
that?
Oh, that's even better.
That is
Maybe.
fine.
Okay. Just, I need them back. This is called cleaning up the cockpit. Okay? Sure.
Okay, so with that said, now that I'm at the microphone, I'll just repeat. My name is Chelsea Garrett. I'm here with Brian Martin from Deal Mosley Law Firm. We represent several property owners that receive notice that are within 150 feet of the property. That's the subject of the hearing tonight. And we believe, qualify as having special damages and should be allowed to intervene. The first owner, I'll just call up Sarah Frericks. If you want to come up here real quick.
Sworn.
Yeah, do we need to swear in?
Yeah, we're gonna need to get her sworn in. You wanna go ahead and get all your folks sworn in?
Yeah, we could. Why don't we have, so
Just
Mary
yours.
Lee, Sarah, Chris, and I think that was it, and Ross. Or just one of you, is fine, yeah. Yeah.
Mr. Chairman,
I think the three of you
do
guys.
you want to, before we get too far into this, bring up questions about potential conflicts, knowledge?
That's a good idea. Let's do that. Let me interrupt you, Ms. Garrett. Well, they're all ready to be sworn. Let's go ahead and do that.
I think you got all of them, please, hand on the same time, do all of them. Do you
Put-
solemnly swear?
Put your left hand on the Bible and raise your right.
Oh, raise your right.
Raise your right.
Oh, raise your right,
There you go.
left and raise your right, there we go. Do you solemnly swear that the evidence you shall give to this body in this matter being heard shall be the truth, the whole truth, and nothing but the truth, so help you God?
So just to preface my questions,
Let me do a couple of
oh,
things.
sure.
Mr. Walker's reminded me of it, just to make sure we get these in before we go any further. All the board members have received the staff report. Did any of the board members drive by the property in question? We're able to do that, but let's ask who did. I did. Okay, Mr. Starnes did. Mr. Schiller did not.
I did.
Ms. Murphy did. Mr. Walker?
I did, and I'd also like for everybody's benefit, I'm one of the neighbors who received notice.
Okay.
I'm within that 150 feet.
Okay, all right. Having received that notice, do you have any bias or preconceived notions going into this?
No, I don't.
Okay. Let's talk about conflicts and bias. A board member on this case must not participate or vote in any manner that would violate an affected person's constitutional right to an impartial decision maker. Impermissible violations of due process include not disclosing any ex parte communications a member had prior to the hearing. Anybody have any prior to the hearing conversations about this case with anyone? Okay. Everyone says no. A member must not have a fixed opinion prior to this hearing as to whether the particular variance should or should not be granted. Does anyone have a fixed opinion prior to this hearing as to whether this isn't a variance, whether this appeal should be granted? Anyone have any preconceived ideas about that? Everyone says no, they don't. A member must not participate in this case if the member has any close familial, business, or other close relationship with the person involved in this case. Anybody have any such connections to this case? I do not. I'm saying no from everyone else. And a member must not have any financial interest in the outcome of the case. I don't. Anyone have? They all say no, so we'll move on. The Court of Appeals has said that we should let everybody know what our procedures are and how we operate, and I'm going to do that right now. This hearing is a quasi-judicial hearing. It's conducted according to the rules and laws pertaining to quasi-judicial hearings. It will have all the essential elements of a fair trial. Parties will have the opportunity to give evidence, cross-examine witnesses, inspect documents, and testimony shall be under oath. The board's findings will be based upon substantial, material, and competent evidence. The North Carolina Court of Appeals has said that the decision of a board such as this must be based upon substantial, competent, and material evidence. And North Carolina General Statute 160D-406J says the same thing. Substantial evidence is defined by the Court of Appeals as that which a reasonable mind would regard as sufficiently supporting a specific result. The court's also said it's such relevant evidence as a reasonable mind might accept as adequate to support a conclusion. Material evidence has been said to be evidence having some logical connection with the consequential facts. Incompetent evidence is generally defined as synonymous with admissible evidence. It follows the rules. We are supposed to follow the North Carolina rules of evidence, the rules used in the North Carolina General Court of Justice. The type of evidence question that most often comes up is hearsay evidence. Hearsay is a verbal or written statement made prior to the hearing, and the declarant is not here or on the telephone to testify under oath. The rules say hearsay is not admissible unless allowed under a statute or by the rules. And the rules have a number of exceptions that will allow hearsay to be admitted into evidence. Probably the most used exception to this rule against hearsay is the exception for statements that were made outside the hearing by a party opponent. The party opponents here today are the appellant and the town, and there may be an intervener, we'll see shortly. They're opponents, and what they or their agents or employees have said outside the hearing is admissible as a statement by a party opponent. It's a hearsay exception. We, the board, cannot make critical findings of fact based on hearsay. And if we hear what sounds like inadmissible hearsay being offered into evidence, we shall stop and discuss that situation with the parties. Mr. Hollister, our minute taker is Miss Allison Wanyu over here. She works for the town. She actually works for Mr. Rothrock. Do you have any objection to her keeping the minutes of this meeting?
No.
Okay, all right. Mr. Rothrock, do you have any objection to your assistant keeping the minutes of this meeting?
No.
Okay, all right. Ms. Garrett, thank you for your patience, if you would continue.
Thank you. So, as you guys may have dealt with before, because this is quasi-judicial, the North Carolina statute 160D does not allow anyone other than the applicant and the board to present evidence unless they intervene. That is why we are making an oral motion to intervene. And in order to intervene, we have to show we would have standing. The standing is determined under 160D 1402. That states that fallen persons have standing. That would include, of course, an owner of the property, which is here. And it includes any other person who will suffer special damages as the result of the decision being appealed. And courts in North Carolina have consistently considered some evidence of special damages to be the fact that if the ordinance already provides that folks within 150 feet of the subject property have special interest, such that they've received special direct notice, that is some evidence that they would, by virtue of the town's own ordinance, be separate and viewed separately from general community members that might want to come in and just speak to any application. On top of that, though, I would ask each property owner here to state their proximity to the property and what their concerns are. I believe it's clear under the law I think due process rules would support allowing these particular owners to intervene. So I'll just let them speak as to their particular proximity. So Ms. Frerichs, okay, good. Could you give the board your full name?
Sarah Frerichs,
Can you spell your last name?
F as in Frank, RERICHS.
C-H-S. Okay.
Okay, and Ms. Frerichs, where is your property here in Rolling Rock?
It's 491 Chestnut Drive, so 2 doors away.
2 doors away,
Yep.
okay. And is it a single-family residence?
Yes, it is.
Okay. And when did you purchase the property?
October 2023.
And when you purchased the property, did you inquire as to whether short-term rentals were permitted at your property or anywhere near you?
I did.
Okay, who did you ask?
Our realtor, Ruth.
Okay, and what were you told?
We were told that there's an ordinance that prohibited short-term rentals.
Okay. And was that a factor in why you purchased this property?
Absolutely.
Would you have purchased the property if you had been told otherwise?
You know, I can't answer that, I guess, because I don't know what I would have done back then, but I would like to say I wouldn't, because I like my neighbors, I like the spirit of the neighborhood, I like having neighbors, I like knowing my neighbors, I like knowing who's gonna be there if I get in trouble, if I fall down on the ice, I like knowing who they are, so, I would say that I wouldn't buy it, but you can't go back.
So what are your concerns related to having a short-term rental as a neighbor?
Well, I do short-term rentals frequently throughout the years in different places in the United States and the country. So I know what it's like to have to go to a short-term rental. And I'm not bad to the property, I don't fear that, but it is a different feel. You don't know your neighbors. You don't know, I can't call them up. Like, you can look out the window and see what Bill's doing. I don't know them because it's somebody different all the time. So it just gives it a different feel and a different feel.
Okay. Do you have any concerns about impacts of a short-term rental as opposed to a permanent resident?
Well, I have a concern about it impacting the value of my home.
Okay.
Because I would not have paid what I paid for that house had I known that there could be other short-term rentals.
Thank you. I don't have any further questions. Does the board have any?
Does any board member have any questions of Ms. Frerick? Is that what you said?
Thank you.
Mr. Chad Hollister may want to ask her a question.
I do not.
Please state your name
And Mary Lee Howell.
and where.
I'm sorry. What was it?
Mary Lee, Leigh, Howell, Howell.
Okay, thank you.
And Ms. Howe, where is your property located?
50 feet behind them.
Okay. What is the address of your property?
We are 135 Pine Village, so we are the very first townhouse we get to in Pine Village.
Do you have, you said 50 feet, do you have a clear view of the subject property?
Oh, yeah.
Okay. And are there any porches or decks or patios?
There's one balcony, theirs, right? Yeah, one balcony, that's directly in front of our door. And then an entrance to a basement apartment is also there.
Okay. And what, do you have concerns about the subject property being allowed to be used for short-term rentals?
I've got at least 3. Let's start with light, noise, and property value. The light thing being that when they come around the end of the parking lot also sits directly in front of us. So if that means somebody comes up at night, it means they shine their headlights directly into our primary bedroom on the first floor, which is not fun, understandable, shades. So we prefer that to be as little as possible. The second would be noise. We have a wonderfully quiet neighborhood on Chestnut Street. And I own real estate. I've short-term and long-term rented, and I can tell you the difference in the renters and what they're like. So my second would be the noise thing. My third is property value. I've been investing in property for more than 20 years. I've had property in Blowing Rock since 2017. We have 2 places. And I can tell you that wealthy people do not like to buy in STR-friendly neighborhoods, period.
Okay. Any other questions?
Questions, Amy?
No?
Any board member have any questions?
Mr. Hollister, you know?
Mr. Hollis?
I do. Ms. Howe, if you're within 50 feet, did you receive the formal notice from the town?
Can you say it
Sorry,
louder?
did you receive the formal notice from the town?
Yes, yes, we did.
Please state your name
Chris Kemper,
and you want to spell that?
Kemper.
I'm sorry.
Kenper.
K-E-E,
Emper.
thank you.
And do you own property that, well, let me ask first, did you receive the notice from the town?
We did.
Okay. And where is your property located?
143 Pine Village. We're right next door to Mary Lee Howe and 60 feet from the property.
Okay. And when you purchased your property, by chance, did you inquire about the ability to do any short-term rentals for any of you?
We did,
Okay.
and we were told that they weren't allowed.
Okay. And when did you purchase your property?
March of 2021.
Okay. Since you purchased your property, are you aware of any short-term rentals at the subject property?
I am not.
And what concerns do you have regarding whether short-term rentals would be allowed at the subject property?
It's the same concerns we've heard from the other 2 owners. We have those same concerns. You know, property values, noise, not knowing who's coming in and out, safety. I do have 3 kids, so that's always a concern. Not to say that it would be rented to anybody of danger, but you know, it's still a concern. So.
Do you have concerns at all about your value on your
Absolutely.
property? Okay.
Yep, absolutely.
Okay. No further questions for Mr. Kemper from me.
Well, you say you have concerns about your value. Tell us more about that.
Well, it's the same thing that the previous owners mentioned, is that when you have the short-term rentals, is that you can run the risk of your property's values going down. And like a lot of the previous people that spoke, is that we didn't buy, you know, in Blowing Rock, especially where we bought, so that we could see our property values go down because of an ordinance that was misunderstood, so.
Would you have paid the same thing for your own property had you known short-term rentals were allowed close by?
So I go back to the same thing that Sarah said, is that I don't know. I don't know that I would, my gut tells me that I wouldn't, but I can't answer that honestly, what I done.
Any board member have any more questions? Mr. Hollister, any questions? Thank you. Thank you very much. Anything else, Ms. Garrett?
No, those would be the 3 owners we believe qualify with standing to intervene.
Board members will have to discuss this for a minute and then take a vote. I'm looking at our literally handbook, the quasi-judicial handbook, a guide for boards making development regulation decisions, written by the UNC School of Government, the professors there. You've heard me say many times, they're the guys that teach the legislators in Raleigh about land use law. They are the people that help to write the laws. I'm looking at their book, and they have gone over the laundry list, as Ms. Garrett did, of ways you can become a party. You have to have standing, and if you're alleging special damages, it's got to be fairly substantial. Common denominator here with the three folks that want to come in as parties are they're afraid of their property values going down. And not to be disrespectful, the book does say vague, and they're citing a case, I'll give the cite in a minute. Vague general allegations of decreased property value are insufficient. And then they cite Lloyd versus Town of Chapel Hill, found at 127 North Carolina Appeals at 347, 489 Southeast 2nd, page 898 from 1997. The secondary impacts of noise and the light and not knowing who's over there are obviously a concern. I'm worried we might be getting too far over our skis if we allow these people to come in. What do you, I don't know, what do you think?
So is proximity alone a reason to say they have standing?
No, you've got to allege some hurt, some
So not
harm.
proximity alone, okay.
No.
May I respond to one thing? before I need-
Absolutely. We would love all the help you can give us.
I was looking for it, I'm trying to find it. My recollection is on the issue, of the property values. That is absolutely right as to, general speculation regarding values, but there is case law that does state, and I don't know how that's phrased in the book, Mr. Springs. But I want to say there's a distinction, which is that an individual property owner is permitted to give an opinion as to the value of their own property. There is a case that says that there's a limited scope that an individual property owner is allowed to say. So even though the property owner themselves has not performed a valuation, and cannot say that there's a specific diminution in value that's going to occur, to say that they may or may not have purchased their property, may or may not purchase it again, may or may not have paid that same amount had they known that. I believe to be sufficient on that point. I would also say, for what it's worth, from a due process standpoint, in my experience based on the case law, I believe the courts fairly liberally construe, as long as there is, number one, the proximity, that they are distinguished, these owners are distinguished from someone 2 miles away from coming in and just saying they don't like short-term rentals, because they would personally visibly see the use of the property and experience the use of the property, good, bad, or otherwise. So I would submit, and I'm not saying this next statement because I would ever even encourage it or that the clients would ever want to do it. I believe based on the law that they would have grounds for a de novo review of the question of intervention. And that boards generally are on the side of allowing it. But that's been my experience. That doesn't mean you have to, so.
EB, I'm not aware of such a case, but if you, I don't know if you have access to it, but.
You represent the town, right?
Correct.
Let's make sure we have the players right.
Correct.
And sure, way into it.
Okay. Well, if you were to look to General Statute 160D-1402,
Right.
J3A, it says that the term competent evidence as used in this subsection shall, regardless of the lack of a timely objection, not be deemed to include the opinion, testimony of lay witnesses as to any of the following. And A is the use of property in a particular way affecting the value of other property. And it doesn't specify anything beyond other property.
Give me the number of the statute again. What was it? 1402?
1402 J3A.
Yeah, that statute says the competent evidence is not to be deemed to include the opinion testimony of lay witnesses as to any of the following. The use of property in a particular way affects the value of other property. Anything from any other board member?
Does Chelsea have the case law?
I'm looking for it right now. Trying to get my hotspot to work.
This is the new 160D, Ms. Garrett, and it's,
Oh, I have the statute pulled up, but what I'm saying is the case law, my understanding of the case law is that statute says lay person's opinion of value, and the case provides an exception that if you're the owner of the property, that you are not a lay person giving that opinion on someone else's value. So that's what I'm looking for.
okay, all right. I just think, fellow board members, that somebody, even if they were allowed to give an opinion of what their property is worth, to speculate as to what having a short-term rental house nearby is going to do to their property value, and that's just not something a layperson is ready to do. I just don't think it's where we should go. Anybody have any other?
I see where you're coming from, but I think if she comes up with the case law, we have to consider that as well, because
Yeah.
we don't want to be put in a position where we aren't giving the people the voice.
Sure. Sorry about all my scribbling.
No, I like having notes.
I'm through with that. Get it away from me.
What does this mean in the legal context?
Proximity is, you go back to that, yeah, but it's not enough just because you're right close by.
But I just didn't know, but they're saying that they're some way. I'm just trying to understand what that means from a legal perspective. Because that's very ambiguous.
It's not whisper. It's not whisper. It's not whispers.
That's not true. That's true.
Yeah, I have, so, one of Mr. brought up the School of Government, which is, I agree, an excellent resource. They have lots of blogs and articles and things interpreting case laws that comes out. One of them is a blog from Adam Lovelady, Can the Neighbor Speak? Can the Neighbor Appeal? Standing in Quasi-Judicial Hearings. It discusses a couple cases. One of them is the Mangum versus Raleigh Board of Adjustment case, which says proximity is a factor in standing but not determinative. as noted in the case of Mangum versus Raleigh Board of Adjustment, which is a case from 2008 Supreme Court. While proximity in and of itself is insufficient to grant standing, it does bear some weight on the issue of whether the complaining party has suffered or will suffer special damages distinct from those damages to the public at large. And in Mangum, the court allowed the interveners, the board at the first level, and then of course on appeal, affirmed the intervention, stating that that they had standing based on a combination of proximity and potential injury. The interveners own property contiguous to the subject property, which we have here, or in the immediate vicinity. Interveners access their property by one road, the same road accessing the subject property, and the proposed increase in density on the subject property, that's an increase in density issue, but they testified as to traffic, light pollution, noise, and other related pollution. So in that case, there was no reliance on even diminution of value testimony. It was purely concerns regarding light, safety, noise, traffic, light pollution. That again, that's the Mangum versus Raleigh Board of Adjustment. Let's see if I can find another one.
Wouldn't you agree that the building has 4 units? Wouldn't you agree that there are going to be 4 families there at some point, regardless, and they're going to all have cars, and they're all going to be human beings and make some noise?
Well, that's true, but I think I guess if what you're saying is that short-term rentals have the same impact that regular permanent residents do, your own ordinance says the opposite. Your own ordinance regulates short-term rentals and specifically says because of the negative impacts of short-term rentals. So the town has already determined as a matter of law that short-term rentals have a distinct impact from permanent. And I would also just say this, if you think about it from this perspective, there is this process of intervention. We have to go through this. I understand we have to show certain, at least make a good faith showing of certain special damages. There's really, you could argue that if you continue on the rationale that you're taking, then nobody's going to be able to approve special damages or ever intervene in a case of this type again, because what are going to be, the impacts are always going to be concerns exactly as what were stated. So it's increasing use, but those impacts have already been identified by the ordinance as existing. So those are in fact impacts as a matter of law in a sense, because the ordinance is law. Did you want to say something? Okay. And other than them being worried because it's not an ongoing use right now, which is a whole nother issue as to whether it should be grandfathered, but because the short-term rentals aren't there now, they can't speak to what the current impacts are because there aren't short-term rentals. So this is necessarily that evidence is going to have to be in the nature of what it is, which is concerns, legitimate concerns. But that's why I say we're not talking about somebody that lives down the street that's going to complain that there are going to be more cars on my road. This is talking about I live and if you can hear your neighbor barbecuing on their deck, and now it's not your neighbor, it's going to be potentially a different person every few nights, groups of people, and the impacts that the ordinance talks about are the fact that short-term rentals brings groups. It brings groups more than just 1 or 2 people, celebrating special occasions, etc. And I don't have that pulled up, but I can because it is in the ordinance as to what the impacts are.
Mr. Hollister, do you want to weigh in on this? Do you have anything to say?
I really don't.
Okay. Mr. Patrick, do you have anything you want to? Well, we'll have to vote on it, fellow board members. It's,
Chelsea, are you still looking up case law?
Well, Mr. Martin just brought me a case. I was just gonna, and this is a little bit of a one-off, but it does help with the context of the property value issue. And that's where, again, all of these all have slightly different contexts. So just to acknowledge the context of this case is responsible citizens in opposition to the floodplain ordinance versus the city of Asheville. In that case, which is still good law, and it was a Supreme Court case from 83 actually. There are contexts where owners can testify as to the value, and I'm going down to the okay. So owners of properties, in that case, again, just to give context, that was owners challenging a zoning ordinance, okay? But owners of properties which were allegedly subject to a zoning ordinance that allegedly affected a taking of property without just compensation were qualified to testify with respect to damaging effect of that ordinance on the value of their properties. And though the trial court in that case excluded that testimony, which was error, the court determined that that error would not necessarily have been prejudicial. So that was the context of how it was discussed. But the point is, an owner can testify as to the value of their own property. Now, you can decide on what weight you give to that and all that, and all those contexts, but this is not a lay person giving an opinion of value the same way you would exclude somebody who is not qualified as an expert because they're allowed to give an opinion of their own property's value. So,
Ms. Garrett,
but again, I don't think we even need that. Honestly, I would rest on all the other impacts, so.
what's the number for that court case?
308 and C 255.
Thank you.
But again, I honestly think, I don't wanna get too far into the weeds on the value issue, because if you wanna even ignore that, that's fine. I think the impacts, the other impacts are sufficient.
Let me read what the School of Government said about secondary impacts. The individual alleging standing must show secondary adverse impacts particular to his or her property. For example, impacts related by traffic, parking, security, stormwater runoff, littering, and noise may be key factors in depreciating property values. The essential element is a credible allegation of harm to the use and enjoyment of a particular property. And then I'll go back and say vague general allegations of decreased property value are insufficient. The essential element is a credible allegation of harm. I just, we'll see how the board.
But, and I would just say, you keep coming back to the value. Those other impacts don't have to be impacts on value. They can be impacts on enjoyment. It doesn't have to be a value impact. So I'm gonna go find, what section is the short-term rental?
Article 10. Towards the end. I think it's 10. Just what it defines the rules. Ten, 16-10, 12. And in fact, it's in your packet. Yeah, it's in the packet too. It's right here.
All right, Mr. Patrick, you ready? Move on. All right, fellow board members, we're gonna do a motion and a vote as to whether, and we'll take these folks one at a time, have met their obligation for standing. I think you get the idea. It can't be vague and very speculative. It's got to be a very credible allegation of special damages. So, from the first person that came up, Ms. Frericks, forgive me on that. I'll note that,
Mr. Springs, somebody in the back, I can hear you speak up a little bit.
Okay.
Use the microphone.
we'll start with Ms. Frericks. I'm going to note that maybe I didn't take good notes, but it's the damage to property values that is the most, well, I think that's pretty much all she hung her hat on that.
No, I specifically didn't. I specifically just repeated several times that you could throw out the property value argument and then we have other negative impacts.
Okay, I didn't hear any other impacts from Ms. Frerick. Do you want to reopen her direct examination? I heard her talk about property value. I didn't hear anything else.
Well, she spoke to being concerned about, generally about safety, from having, not knowing neighbors and having strangers be down the street, so, or 2 doors down. But that was it. I apologize, Mr. Springs, I thought you were referring to, I didn't realize you were referring to Ms. Fair. I didn't hear who you were speaking to.
I'm sorry, I'm a mumbler. Fellow board members, all I heard her say was she was worried about property values. Anybody hear her say anything else?
Her safety.
Yeah, I heard safety.
Safety as in the context of knowing her neighbors if she were to slip in the ice, for example.
Okay. All right, we'll take them one by one. The motion has to either say she's established standing or she hasn't. I'll say I got to pick one or the other. I'll pick has established standing, and if you don't think so, you can say nay. So make a motion that we find Ms. Sarah Frericks has established standing to enter into the case before us. Is there a second?
I second it.
And Mr. Schiller seconds.
Can't hear anything, nothing.
I'm doing the best I can.
Did those just record or did they also?
I don't. They're dead. They're dead. I'll try to speak up. All those. No, I don't think.
Mr. You can hear her.
All right, is that better?
Yes.
Yeah.
Okay.
Mr., are you closing discussion?
I'm sorry, I was going to. Do you have further?
I'd just like to discuss.
Sure,
Further.
let's go back before I withdraw the motion, and let's have further discussion on Miss Sarah Frerick's situation. Mr. Walker?
I'm talking more in general.
Okay,
But
go ahead.
If I go back to 1402 J3A, it says, well, it says two things in particular. Value of your use impacting other property, value of your property, and specifically says increased vehicle and traffic are both conclusively incompetent. Conclusively. And it's, in general, what I've heard is personal safety, light, noise, and then property, all of which to me are vague. Light, noise, safety, that's all vague to me and leads into property value. Seems like secondary concerns. Or hypothetical concerns.
I think they're legitimate concerns, but I just don't think there's been enough put before us to get to greater standing. Anybody
I just want to see
else?
if anybody had any other
I think the
thoughts on
the idea, what all that noise is. I'm a full-time resident in a Chitola condo, and there are short-term rentals all around me. And I can tell you from my experience that there is additional noise and unsettled things compared to a full-time resident or like a person who lives in Florida and comes up in the summer, compared to a short-term rental where you sometimes have multiple cars, multiple people, and making a significant amount of noise, more than a person that just lives there. They might drive up, take their groceries in. For a short-term rental, you're going to have more activity, and it can be disruptive, but it's not necessarily so. My wife and I rent Airbnbs, and we try to be, courteous, and yeah, we unload a whole bunch of stuff out of our car. We're going in and out. And that can be, disruptive to someone who is a full-time resident or, not renting their place out. So for me, I hear these three people and I think they have standing, just based on my own experience. Now, the law is another issue, and there could be fine lines that we need to delineate. But to
Well-
me, just the idea of a short-term rental means additional impact on the neighborhood. Cars coming and going more frequently, people coming and going more frequently, and potentially, loud parties.
Can we read what the town says?
Yes,
Please.
that's okay. I know it's a little out of order. I tried it. So the section 16-10.2.12, short-term rentals. The board finds that short-term rentals are an appropriate use given the residential resort character of Blowing Rock's planning jurisdiction, provided that specific controls are in place to regulate parking, trash, noise, tenant safety, and other related effects, thereby protecting neighborhood property values and the health, safety, and general welfare of town citizens and visitors. That specifically finds, that means that short-term rentals have specific impacts on parking, trash, noise, tenant safety, and other effects. That will have impacts on property values, health, safety, and general welfare. So I understand what Mr. Walker is saying, and I don't disagree, but it isn't all necessarily tied to values. It is, those are impacts that we have been permitted, the law has allowed the town to find make short-term rentals different from permanent residential use. The other thing is the testimony has to be speculative. Again, you're talking about a use that doesn't currently exist. That's like saying you're not allowed to testify to the impact of a proposed hotel because it's not there yet. It's not happening right now. So they are speculative. They have to be. There's no way for you to get better evidence of that. So in my humble opinion, those are not reasons to deny standing because they're impossible to prove.
Should we go back to the motion?
All right, have we closed discussion?
No, the town has passed this ordinance saying they think short-term rental is different. How can we stand up here and say they're wrong?
Well, I think
We're doing opinion, the town has already passed this ordinance. I mean, to me, that's different subjects. We're speculating. And they've already made the case for short-term rentals need special handling. And I don't know what kind of special handling they get here, so.
well, we can't say because of the town made that pronouncement that all standing shall be allowed. We can't go there. It's a very fact-specific situation. We got to look at this case. Each one of these three people, what they say their situation is.
Is there anyone who might say if these people don't have standing, then no one does?
Yeah.
Say that again.
That if these people don't have standing, then really no one does. They live within 50 feet.
Well, I'm asking a different question. Why did the town do this if those people don't have staff? They have to have staff.
I think so.
All right, well, let's
It's
go ahead.
not 5 people making a decision, it's the whole town has elected people and asked that short-term rentals get handled differently. I mean, we can have opinions. I don't even know whether they have a different property owners association to handle these issues.
And Kevin, can you speak to why we send out notices to all the people within a certain proximity of the property?
Well, simply the statute's required,
Okay. But hopefully there's a reason behind it.
yes.
All right, well, let's move on.
I
Let's,
don't think I'm trying to make a case either way. I'm saying the town already had this opinion. So we have to say they have a standing, or the town wouldn't have this ordinance, or whatever this is called.
all right, let's take them one by one.
I've got one more
Sure,
comment.
sure.
Mr. Schiller, right? Mr. Schiller gave his personal opinion based on Chitola and where he lives about, again, for him, it wasn't hypothetical, but it was all secondary impacts. Is that even admissible here, his personal opinion?
Well, our discussions have to be in public, and he expressed that.
But his
opinion.
personal opinion
His
sounds to me like a potential predisposition to where this heads.
It's a predisposition to allowing standing because there is an impact. I mean, I had seen the impact, so I just project that onto other people. They're going to have a similar, they've come forward because of the notice. They want to speak, they want to say, in opposition to the short-term use because of the potential impacts. I see the impacts. Now, it's my opinion that it's an impact. But it's,
Thanks, I just wanted to clarify.
yeah,
Sure,
no,
sure.
It's my
Well, let's-
opinion. I agree.
We've kicked it around. Let's see how the vote goes. I have a pretty good idea how it will, but I move that we find that Sarah Fryricks has established special damages sufficient to have standing in this case. Do I have a second?
I second.
Mr. Schiller seconds. All those in favor of finding that she has established standing, say aye.
Aye.
All those that think she has not shown sufficient special damages, say nay. Nay. So it's 3-2. And so she has standing. Moving to Mary Lee Howell.
So you voted no?
I voted nay. Okay, it's 3. She has standing.
I just didn't hear his vote.
Yeah, I said nay. It's 3-2. On Mary Lee Howell, anyone have any discussion on her situation and her special damages? Anything further?
Are we voting whether she has standing or not? What's the specific?
Yeah, I've got to make the motion either didn't make her case or did or did not. I'm just choosing to make the motion that she did establish standing. And if you don't think she did, you say nay, like I did on the last one. So I make a motion that we find that Mary Lee Howell has established sufficient special damages to establish standing. Is there a second? And Mr. Schiller seconds that. And all those finding that Mary Lee Howell has produced sufficient evidence that she has special damages and deserves standing, say aye.
Aye.
So that's 3. All those that feel like she has not produced enough to deserve standing, say nay. Nay, that's 2. So she does have standing. She's allowed to come into this case, as does Sarah Fryricks. Moving to Chris Kemper. Any more discussion on Mr. Kemper's situation? All right, I make a motion to find that Mr. Kemper did produce evidence of special damages such that he deserves to come into this case as a party. He has standing. If you think he does, say,
Need a second.
oh, I'm sorry. Do I have a second? Mr. Schiller again is the second. All those that feel like he has established standing, say aye.
Aye.
And all those that feel he has not, say nay. Nay. It's 3-2 again, so he is allowed to come in as a party. All right, moving along. Let's swear all the witnesses, the potential witnesses that haven't been sworn in yet. Let's do them as a group if we could. Come on up.
Do you solemnly swear or affirm that the evidence you shall give to this body in this matter shall be being heard shall be the truth, the whole truth, and nothing but the truth, so help you God?
All right, we'll start with the town of Blowing Rock. And the person that's going to state their case, come on up.
One point, point of order, just the order of evidence, but, the appeal by Mr. Hollister, which I think he has the right to go first, but from an evidentiary standpoint, I have a question about whether we are going to be talking about this property as one property or four. And the reason for that is that these are four legally distinct real estate units that were acquired in one deed, but have been previously owned based on their chains of title by multiple different owners, individually, sometimes together, sometimes separately, and that each unit and the history of rentals and whether any one unit should qualify has to be taken separately. It's not the property as a whole. This is not an apartment building. These are separately, you could convey any one of these units in a separate deed to someone else. And they were owned separately and could have been rented long-term or short-term separately for whatever the history may be. So I think they have to be taken separately.
Let's, okay, well, let's call that a motion and let's see what Mr. Hollis, if Mr.
That's totally
Hollis.
fine. I just wanted to make that clear up front because I think it's viewed a little, it's sort of lumped together in the appeal. And, so that's it. Thank you.
We'll get Mr. Hollister to speak to that. Let me look for something.
We gotta get some evidence. We gotta get people to, we gotta get them out to apply. Well, we got two. Well, it's one property. EB, do you want me to lead off and go through the staff report, and then y'all can decide how you want to?
Let's go ahead and get this addressed now. I'm looking for some ordinances that may pertain. I'm looking at Blowing Rock Ordinance 16-8. (16-8.6.2), and I've got some extra copies of it. If any of the parties would
That's
like.
right.
Mr. Hollister, would you like a copy? Mr. Rothrocker, do you want a copy?
I gave him out. He has a copy.
Okay, all right. Ms. Garrett, I'm looking at section 16-8.6.1. If the principal activity on property where a non-conforming situation other than a non-conforming use exists is well, short-term rentals is a use. I'm sorry, look one notch down, 16-8.6.2. For purposes of determining whether a right to continue a non-conforming situation is lost pursuant to this section, all of the buildings, activities, and operations maintained on a lot are generally to be considered as a whole. For example, the failure to rent one apartment in a non-conforming apartment building for 180 days shall not result in the loss of the right to rent that apartment or space thereafter, so long as the apartment building as a whole is continuously maintained. At any rate, let's see if Mr. Hollister can shed some light. Can you come up, Mr. Hollister? Okay, who is the owner of the property now? Rock
Pine Rentals, LLC.
and it's owned by James Hollister.
Yes.
When did Rock Pine Reynolds buy the property at?
I believe we closed the first week of September of 2025.
Let's see, let me get the address right. 439 Chestnut Drive, units A, B, C, and D in Blowing Rock. Rock Pine Reynolds bought it when?
I don't know the exact date, but it was around the first week of September of 2025. I forget the exact date.
When I was trying to figure out who the owner was, because you had said you were the owner, I checked the land records and I see that property being sold. I see George R. Collis and Stephen G. Buchanan selling that property to Rock Pine Reynolds on August 28th, 2025. Does that sound all right?
That sounds right, yes.
Bought all of the units, all 4 units.
Yes.
Okay. Ms. Garrett, do you have any questions for Mr. Hollister?
Does Mr. Hollister want to present his evidence, and I can ask him questions after that?
No, we're talking about your concern, which I'm not quite clear on, about these 4 units.
So, I think it's more of a legal point than anything, because these units, it's not an apartment building. And because these units have been separately conveyed and owned through the course of, there could be one that was never short-term rented ever. How could that possibly qualify for grandfathering? How could you possibly say that the entire property could be grandfathered? So you have to be able to prove each one was, whichever ones he proves can be grandfathered, could be grandfathered.
Okay, thank you, Mr. Hollister. Does the town have any questions of Mr. Hollister?
As far as Chelsea's motion? Or
Do you have a motion?
Oh, it's not not so much emotion as it is, I think if, I guess, the only context I know how to say this is, if this were to go to a court on appeal by him or us,
Right.
the question would be, was there competent material evidence below? And if there's not evidence of grandfathering, if you only receive evidence of grandfathering on one unit, for example, I don't even know what the evidence is gonna be, I would submit you don't have evidence to conclude that 3 other units are grandfathered. And I'm just trying to limit the issues we have to argue about on appeal if that were to happen.
Okay.
Because that is, I think, important. These are 4 distinct legal units. So, and unlike like a Royal Oaks situation, you know, I think it's distinct. I also think, unfortunately for all of us, ordinance drafting is a hard thing, and it's hard to contemplate every possible scenario. Now that we're faced with this scenario, I think we'd all agree that that's not well worded. Because obviously you wouldn't say that all buildings on an entire property, if one building was rented, means all buildings can be rented and grandfathered. I'm sure that wasn't intended, but that's what it says. And I'm just making the point, I don't think that that's what was intended by that clause. I don't know that it really matters until he's presented evidence, because the evidence will control whether something had a history of short-term rental or not. And you can make that decision later if you decide to grandfather something. I just wanted to make it clear, I think our position is that's not, you can't treat it, you can't lump it all together, is our position. You guys don't have to agree with that position.
Okay.
So I have a question and
Sure.
observation as well. So looking at that statute, the word that I hone in on is apartment. As opposed to any other classification of a residence. But the question that I have for Ms. Garrett is, are you suggesting that we bifurcate this into 4 separate hearings?
No, I don't mind I don't want, unless Mr. Hollister wants to do something different, I don't want him to feel like he's gotta present anything differently. But I didn't want to wait to bring this up at the end of all the evidence. I felt like it was only fair to say, we don't think, and we'll be arguing that you have to show short-term rental use on each unit, not just one unit at some point to qualify. And I don't think it's fair to tell him that at the end.
Okay, all right, well, thank you. All right, Mr. Hollis, you can sit back down. Thank you. We're gonna lead off with the town, and they're gonna make their presentation. And then we'll, move on to Mr. Hollister and then to the, 3 interveners.
All right, ready?
Sure.
Okay. I want to read this into the record, and the attachments and exhibits are included as part of that and referenced in the staff report, and I'll just read it into the record. And then answer questions after.
All right, let me say one thing. The staff report is not evidence. It's sent out to get us up to speed on the case so that we can get familiar with it and not be hearing about what kind of case it is for the first time tonight. It's not evidence. And if somebody wants some part of the staff report to be evidence that we consider in our decision, they need to say, I want this to be in evidence. All right, Mr. Rothrock, I'm sorry I interrupted you. Go ahead.
Rock Pine Rentals LLC has appealed a final administrative decision, which is included as Exhibit A, sent to Chad Hollister as a registered agent of Rock Pine Rentals LLC on November 13th, 2025. The administrative decision dated November 13th, 2025 denied Rock Pine Rentals LLC's request to allow short-term rental at its property at 439 Chestnut Drive in Blowing Rock. The subject property is zoned R6M, multifamily, where short-term rental is not permitted. The property is further identified by Watauga PIN 2807-965192-000. Mr. Hollister presented information to the town after Rock Pine Rentals LLC purchased the condominium building at 439 Chestnut Drive, units A through D, from Greg Buchanan and George Collis in August 2025. The information and request from Mr. Hollister claimed through an affidavit that Mr. Collis rented units on a short-term rental basis less than 28 days prior to 2019. Once the town modified the zoning ordinance in August of 2019, consistent with the North Carolina Court of Appeals decision related to short-term rentals, Mr. Collis claimed the town informed him he could not continue with short-term rentals. Planning staff is not aware of Mr. Collis ever renting units on a short-term basis, and we have been provided no evidence that indicates Mr. Collis did. To our knowledge, it does not appear that short-term rentals ever happened at 439 Chestnut Drive, and no occupancy tax receipts are available that would indicate compliance with the town's occupancy tax laws for any rentals less than 28 days. Further, planning staff is not aware of ever having a conversation with Mr. Collis, informing him that short-term rentals were no longer permitted at his property. Even if Mr. Collis had rented short-term rentals on the subject property prior to 2019, which the planning staff contends that the applicant has failed to prove, the applicant produced evidence that runs counter to its request, confirming that no short-term rental activity has occurred on the subject property since 2019. Pursuant to section 16-8.6 of the town's land use code, any non-conforming use that has been continued for a consecutive period of 180 days is deemed abandoned and cannot be reestablished. Here, the alleged non-conforming use has been discontinued for a consecutive period of at least 180 days, starting in 2019 at the latest, thus abandoning the alleged non-conforming use of the subject property. Accordingly, in response to the applicant's request for allowance of short-term rentals at 439 Chestnut Drive, staff denied this request based on there being no evidence of prior and continued short-term use in an R6M multifamily zoning district where short-term rental is not permitted. Public notice for this appeal was mailed on January 19th, 2026 to the property owner and adjacent property owners within 150 feet. That's Exhibit B that's in your packet, has a map and the list of addresses that were included on that map. Property was posted on January 9th, 2026, and a public notice appeared in the Watauga Democrat on January 14th and 21st of this year. In the attachments that have been provided to you, there's a letter of decision dated November 13th, 2025, appeal application dated November 20th, 2025. Mr. Hollister had provided supporting documents of his appeal, and those have been included as Exhibit C. Exhibit D is public notice and mailing list and the map. Exhibit E, aerial map of the subject property here. Subject property in red there as you look on the screen. Zoning map of the subject property, and then we also included ordinance sections that pertain to short-term rental, and I believe part of the use table that shows where short-term rentals are allowed and where they're not.
Okay.
Couple pictures. This shows the property in 2021. From the street again in 2024. An aerial of the property, and we've been looking at that most of the night, but we can see the property located here. Pine Village, where some of the neighbors that have spoken tonight is right here. And everything else on there is self-explanatory, I believe. Then we have some code sections that I placed in front of you tonight dealing with nonconformities and abandonment of nonconforming uses and situations. That's all I have. I'll be glad to answer questions.
Do you want to put anything in the staff report? Do you want to put any of those pieces of paper into evidence?
All of it.
All of it?
Yes, sir.
We would object to the affidavit.
Okay, on what grounds?
On the ground that there's not a justification for an affidavit to come in based on the rules, procedure that witness, the applicant is local and in town, is not available.
You're saying it's hearsay?
It's, yeah, the objection is hearsay based, and that it should not be admissible because there's not a reason for that hearsay to be overcome, that the applicant is available.
Okay. Mr. Hollister, what do you have to say about that?
I would say it's a sworn affidavit that was notarized. I feel it should be permitted.
Okay. Mr. Petrick?
Got nothing to add.
Okay. The affidavit, unless Mr. Collis appears tonight to testify in person or by phone, is hearsay and will not be put into evidence. Anything else you would object to, Ms. Garrett?
No.
And Mr. Petrick, you're the one that wants the whole package in, so I'm assuming you agree with Mr. Rothrock, the whole package, with the exception of the affidavit comes in, or do you want to exclude anything else?
There's nothing else in the packet beyond the affidavit that needs to be excluded.
So, Mr. Hollister, do you feel like there's anything in the staff report that should not be come into evidence and be part of our deliberations?
Some of the statements made about, it seems like they're hearsay, that they don't recall talking to Mr. Cullis about anything, things like that. I would say.
Well, that was Mr. Rothrock
Yeah,
talking.
that was a staff report though, right? Wasn't you reading the staff report?
Yes,
Okay.
That's me, that's not hearsay, that's me stating it.
right.
And I'll speak to that if you ask me.
But if the other town employees are not here to, if I can't submit an affidavit, I don't know, if other town employees' word of saying that they did not talk to Mr. Cullis.
Well, hearsay involves actual words. If, I don't see actual words here. He's talking in general terms,
Okay,
but he's not saying what they told him.
okay.
So it does, hearsay deals with the actual words or written words. Anything else, Ms. Garrett?
No, thank you.
Okay, so in the staff report, everything but the affidavit comes into evidence.
Mr. Chairman, do we need to vote on the affidavit? Because I understand it's hearsay. But
The rules are on objections, the chair makes a ruling, and if anybody objects to that ruling, then we take a vote of the whole board.
thank you.
You're welcome.
Am I right in understanding that the board has the ability to determine if they want to listen to the affidavit?
Well, we can read the affidavit,
Yeah.
and the affidavit's,
And you can decide what the weight is of it?
and, well, it's hearsay, and we're not gonna let it into evidence because it's hearsay.
Okay.
I think what Mr. Hollister is trying to do is object. You just said that the chair makes a decision and then unless a party objects, the chair's decision holds, otherwise the objection allows discussion. Is that what I understood?
Yeah, I guess
And
I
I
thought I
think
had
you're
objected
trying
to it. Yeah, I thought I objected to not allowing the affidavit earlier.
Okay, all right, do you want a vote of the board? All right, you're entitled to a vote of the board. I don't know that we need to put this in the form of a motion, what do you think?
It's a matter of voting whether we accept the
Yeah, I think it's
affidavit.
just a straight vote. All board members,
Would it not need to be a motion that's then seconded and open for discussion amongst us?
what do you want to, yeah, of course we'll discuss if you want to. Go ahead.
So I'll move that we do not accept the affidavit as hearsay, because it's hearsay.
Is there a second?
Second.
All right.
All right, so,
What I wanted to discuss, now that we have a motion, is you were quoting the North Carolina, what's the book called?
Rules of court.
You said it's introduction of the affidavit is hearsay, but it's discouraged,
yes,
discretion of the board.
yes.
So it's not a matter of cannot use it, it's a matter of whether we give it any weight, right? Am I understanding this correctly? That's what I'm asking.
We can't accept hearsay.
Well, no, we can accept this affidavit and give it the weight that we believe it deserves. It's discouraged though, but it's not prevented, it's not. Unless I misunderstood what you said earlier.
Well, it's in the record, but it's not evidence. And looking at it, I would say it's classic hearsay because it raises more questions than it answers. I look at it and I go, I want to ask all these things of this person, and I can't because they're not here to testify to it. It just raises so many questions and it carries so many legal issues. It's the classic problems with hearsay. Anything else from any board member? Okay, so,
And I don't know if this bears on this case, but in the past, we've never accepted an affidavit as, correct?
Yeah, they have to
And-
be available on the phone.
Yeah, people
They
have
can't
showed up
be
on the
here.
phone or
it's,
Zoom.
well, if they're on the phone, it's
Yeah.
not hearsay.
Yeah.
We can ask him about.
And again, I don't know if that has any weight, but or any bearing, but I just feel like we've had this conversation several times and we've always not taken an affidavit.
Years ago, we took affidavits, and it was such a mess that we passed this rule that we didn't say definitively, never, ever, ever, but we strongly discouraged because it does violate the rules of evidence. Anything further? All right, so we need a vote. I'll let you articulate it, Mr. Walker. If you-
I moved that we do not enter the affidavit into evidence as here because it's hearsay.
Okay, and the second was
Second was me.
Ms. Murphy. So all those in favor of upholding my ruling that it's hearsay and will not come into evidence, say aye.
Aye.
Aye. It's unanimous, and so there we go. It's not in evidence. Now, everybody gets a chance to question Mr. Rothrock. Mr. Hollister, did you have any questions of Mr. Rothrock?
No.
Okay. Ms. Garrett?
Yeah.
And
I have a question.
any board member have any
How
questions?
far back do you retain records for the payment of occupancy tax?
I don't know how long we keep them, but I think, and Joey might be able to correct, I think we have the ability to collect them as far as 10 years. That may not answer the question, but those started in 2005 for the town, I think. But how far we can go back, or the records, probably a tax question I can't answer.
Is that the state agency collecting those? Or the town?
No, the town collects those and distributes that to, well, it goes to the TDA and then the town gets a third back.
Any other questions of Mr. Rothrock?
Mr. Chair, I do have one thing that I think could also be perceived as a possible objection. He did, that Mr. Hollister did object to certain portions of the packet, specifically conversations that were maybe held elsewhere. I'll leave it up to you whether you want to provide that with the same treatment as the other in discussion and determination of that amongst the board.
I see what you're saying. Treat him as having objected to my allowing Mr. Rothrock's summary in.
Yeah, I mean, not the entire summary, but Mr. Hollister, if I'm understanding correctly, you were objecting to certain portions where Mr. Rothrock references other.
Other town employees that don't remember anything. Well, I forget exact words.
So
He
you
addressed
would
that.
may clarify, maybe it might help with what he's saying is, when I use the term town staff, I am referring to myself and the only other one that has been here since 2019, that would be Brian. And Brian's here if he needs to be sworn. But when it involves me making a decision or having conversations with Mr. Collis, I can only answer for myself and Brian can answer for himself.
Let me go back to Mr. Hollister. Mr. Hollister, you've got a copy of the staff report in front of you. Read the part you object to. I assume you don't object to all of it. It's,
No, I just,
what part do you object to?
that specific part where he was referring to other town employees and their recollection of events.
Okay, planning staff is not aware of Mr. Collis ever renting units. Is that what you're talking about?
Yes.
Okay. He's not actually saying what any words that planning staff said though.
But the general inclination is that it feels like he's saying that because the staff doesn't remember anything, that it didn't happen. And that seems like hearsay to me.
Swearing Brian.
Can I get some clarification? I understand his general objection to anything in the packet that is hearsay.
Right.
Right. Mr. Rothrock clarified that when he says town staff, he's referring to himself and other town staff that's present tonight.
Yeah.
So are there other statements, whether they're general or otherwise, that you're worried about? Because I understand what he's saying. Mr. Martin and I agree that he referenced information that was derived from someone who is not here is hearsay. I don't have an objection to that. I agree with that. I just don't know which statements he's referring to in the packet though.
This is what you read, Kevin, correct? Like this is what you read verbatim? This page?
No, I was reading the staff. That's my letter.
So this was, you were reading this?
Yes, sir. Okay, gotcha.
Yeah, you just,
Yeah, you're fine.
Mr. Rothrock, you wrote the staff report, so that paragraph you believe is accurate. It's your own paragraph.
Yes. If
I'm gonna leave
the
it.
term planning staff.
Yeah,
is
I'm
re-
gonna, well, that
if
covers
it's-
you.
If that's broad and it just needs to cover me, it can just cover me.
I'll leave it between you and your attorney if you want to bring up Ms. Brian Johnson to plug in the other person and make it definitively not hearsay. I'll leave that up to you two, until that's done. I'm gonna hold a decision in abeyance for the time being on Mr. Hollister's objection. So you said you have made all of of the legally required notices of this hearing to private parties in the public?
Yes.
The property there at 439 Chestnut Drive, units A through D, Blowing Rock, is that in a short-term overlay district?
No.
Does any other board member have any questions? Any further questions of Mr. Rothrock? No.
Just wondering if we had documentation like occupancy tax returns, payments for tax collected sometime in 2019, prior to the passing of the ordinance. Would that show, would that show that there had been rental activity, but we have no such records?
We don't have any records. I sought them out with staff members that are responsible for that. We did not find anything.
And going back to Mr. Hollister, that paragraph on the first page of the summary by Mr. Rothrock,
Yes.
that's your objection. Planning staff
That's
is,
the vagueness of the planning staff.
okay, all
But
right.
if he's gonna put it on the record that it's him and Brian, I don't see any problem with that.
Well, we're going to leave it up to the town to decide whether Ryan Johnson needs to come up and address that section. So, Mr. Rothrock, there are no more questions for you. Thank you very much, sir. Anything else for the town?
No, Mr. Chair.
You're finished with your presentation? You don't want to put Ryan Johnson up?
Well, it is staff's presentation.
So at this point, we don't know what the other person said to lead Mr. Rothrock to say all planning staff is not aware.
So should we make a motion or should we just swear him in? That seems like the easy
Why don't you
answer.
subpoena Brian and have him go up here and answer. And then you can be available to answer these questions.
Do you solemnly swear or affirm that the evidence you shall give to this body in this matter being heard shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah, I just have a question or two with Brian.
Sure.
Are you aware of any conversation that occurred in 2019 or thereabout that is referenced here in the staff report?
No, sir.
Are you aware of any evidence whatsoever that references any conversation that might have occurred during that time affecting this property?
No, sir.
And for the record, my employment started in 2021.
Are you aware of any short-term rental activity that's been occurring on that property since your hire in 2021?
I have not.
Have you received any evidence or any information from anyone that would suggest that there's been rental activity there since the date of your hire in 2021?
No, sir.
I don't have any further questions,
Okay.
Mr. Chair.
Ms. Garrett, any questions? I have one or two. Mr. Johnson, Did you ever talk with Mr. Collis at any time about short-time rentals,
I have not.
short-term rentals? Are you personally aware of Mr. Collis ever renting units on a short-term basis?
I'm not aware, no.
I have nothing further. Any board member have any questions of him? All right. Thank you. Thank you very much. Mr. Petrick, anything else for the town?
No, sir, not on George.
Okay. Mr. Hollister, it's your turn now to make your presentation and present your evidence. If you would start out just by stating your name.
Chad Hollister. I'm Chad Hollister. I represent Rock Pine Rentals. As you heard, my father owns the property. I manage it for him. I wrote a statement just so it would be clear and concise, and so I'll just start. This appeal concerns the denial of a non-conforming short-term rental status for the property at 439 Chestnut Drive. The material facts are straightforward. Prior owners, George Colas and Greg Buchanan, operated short-term rentals at this property well before the town's 2019 ordinance changes. The use ceased only after they were informed by the town that short-term rentals were no longer permitted. There were no voluntary decisions to stop renting, no intent to abandon the use, and no affirmative act inconsistent with continuation of that use. Under North Carolina law, including the Court of Appeals decision in the Fraser versus Town of Blowing Rock, a lawful non-conforming use is not lost absent voluntary abandonment. Compliance with government direction is not abandonment. The affidavit submitted by Mr. Colas establishes prior short-term rental use and confirms that the cessation occurred solely due to the town enforcement, not owner intent. For those reasons, I respectfully request that the board reverse staff's determination and recognize the property's lawful, non-conforming short-term rental use. Thank you.
Mr. Springs, can I make an objection real quick?
Sure.
Just since I haven't spoken, I'll note for the record, my name is Brian Markman. I'm representing each of these interveners along with Ms. Garrett.
Yes.
These interveners would object to the vast majority of what was said right there, in the sense that it's primarily hearsay, any reference to what Mr. Collis said, any reference to statements made to or by Mr. Collis, I think would all fall under that category. And I understand that the board can choose to ignore that stuff, having heard it, but I just think we need to preserve that objection for the record.
All right, Mr. Petrick, do you have anything to say about this?
Nothing further beyond what Mr. Martin said.
So, Mr. Hollister, it's sort of like your objection about the planning staff. They're objecting to what you say happened because they think it's based solely on hearsay. Let's see if it is. Do you know of your own knowledge whether or not these units were short-term rentals prior to August 13th, 2019? Do you know of your own knowledge?
I do not have firsthand knowledge of that. And I would say nobody in this room has firsthand knowledge of that.
Ask a question.
Sure, go ahead.
Do we have any records on occupancy tax or anything from the town standpoint to show that it was ever a short-term rental?
No.
So is it fair to say that he has firsthand knowledge? Kevin?
I didn't find any evidence of receipts or
Right.
Did you not?
acknowledgement of rental at that location through tax receipts.
May I ask a question? Do you have tax receipts going back? Do you actually, where's the last tax receipt that you can bring up? I would ask.
I don't know how far back they go or how far they're kept.
So did you not find any because they just don't exist? There's no paper trail?
Correct.
Okay. So it's not that they don't exist because they're not there. Gotcha.
So you had something to say about intent and abandonment. Can you tell us that again? I didn't catch it all.
Basically, that the previous owners never intended to abandon their right to short-term renting.
Which is based on hearsay.
It's based on the affidavit, which you're considering hearsay.
Okay.
But I will say it's a notarized affidavit, so you take it for what you want.
It's sworn, of course. Our evidence, our testimony has to be sworn, and it meets that requirement. It's just the fact that he's not here.
I understand.
Right.
I do believe in a court of law it's admissible though. So,
Who says a court of law?
now I know this isn't a court of law, but saying it, it is allowed to go into a regular court. That's evidence, I believe.
Well, I might disagree with you there. All right, Mr. Hollister, do you have anything else to add?
I would say that the 180-day rule should not apply here because there was no intent to abandon. So the only reason that the 180-day gap exists was because they were told they weren't allowed to do it. So there was no intent to not do it. If they were allowed to have kept doing it, that 180 days would never have lapsed.
Okay. Ms. Garrett, any questions?
No, we would just renew the objection just for purposes of the record.
Well, I sustain the objection. The hearsay of the affidavit is not in evidence. That document is in the record. That down the road, if somebody, some judge wanted to see everything to do with this case, it would be there, but it's not in evidence. Mr. Petrick, any more questions of Mr. Hollister?
No.
Any board member have any further? Okay, thank you, Mr. Hollister. Ms. Garrett?
Mr. Springs, I think at this time, the interveners would dismiss based on the grounds that there's a lack of sufficient evidence on a basis to meet the criteria for this grandfathering status. The bare bones here would be that there's some testimony, there's some evidence that there were short-term rentals at any point, much less a 180-day gap. But there is no evidence because of what I think were proper decisions by this board as to what's admissible and what's not. There is simply no evidence before this board that there has been short-term rentals at any time relevant to this matter. So I just don't think that the evidence to get to the point of interveners even putting on evidence, I just don't think there's enough evidence to survive to that point and make a motion to dismiss.
Mr. Petrick?
Nothing to add.
It's well argued, Mr. Martin, but I think Mr. Hollister deserves a decision. We'll take a short comfort break, bathroom break, and then the board will start to do factual findings and then conclusions of law. So bathroom break. fellow board members, stop me if I say something incorrectly. And I'll begin. The address of the property at issue in this case is 439 Chestnut Drive, Units A, B, C, and D, Blowing Rock, North Carolina. For convenience, we shall refer to it hereafter as the property. The Watauga County PIN number for the property is 2807-96-5192-000. The appellant is Chad Hollister, representing Rock Pine Rentals LLC. The owner of the property at issue is Rock Pine Rentals LLC. The owner of Rock Pine Rentals LLC is James Hollister. Rock Pine Rentals LLC bought the property from, let's see.
Buchanan.
I think I'll get it correct. Bought the property from George R. Collis and Stephen G. Buchanan. Rock Pine Rentals LLC bought the property on August 28th, 2025. The property at issue is in Blowing Rock zoning district R-6M. The property at issue is not in a short-term overlay district. All proper and required notices of this hearing have been made. The appellant contacted the Blowing Rock Planning and Inspections Office on October 31st, 2025, and he asked the planning director, Kevin Rothrock, to confirm that the property at 439 Chestnut Drive, units A, B, C, D, could be used for the use of short-term rental. The planning director informed the appellant by letter that the property could not be used for the use of short-term rentals. The planning director finding no evidence that the property has been used for short-term rentals since the enactment of the Blowing Rock ordinance regulating short-term rentals on August 13, 2019, a period of more than 180 consecutive days. Blowing Rock Code Section 16-8.6 says any non-conforming use such as short-term rental that was otherwise lawful when the zoning ordinance was amended on August 13, 2019, would have been allowed to continue, provided that the non-conforming use is not discontinued for a consecutive period of 180 days. The planning director based his denial of the appellant's request upon Blowing Rock Section 16-8.6, abandonment and discontinuance of non-conforming situations. When a non-conforming use is A, discontinued for a consecutive period of 180 days, or B, discontinued for any period of time without a present intention to reinstate the non-conforming use, the property involved may thereafter be used only for conforming purposes. The appellant is appealing a final administrative decision, see Exhibit A, wherein the town of Blowing Rock's planning director, Kevin Rothrock, notified appellant that appellant's request to have the use of short-term rentals allowed on the property of 439 Chestnut Drive, units A, B, C, and D, is denied by the planning director. The date of the denial by the planning director is November 13th, 2025. The date of the appeal, this appeal by appellant, is November 20th, 2025. The use of short-term rentals became non-conforming in Blowing Rock zoning district R-6M on August 13th, 2019. The Blowing Rock Land Use Code, hereafter referred to as Blowing Rock Code, in section 16-10.1, table of permissible uses, at use description 1.620, does not allow the use of short-term rental of a residential dwelling unit in zoning district R-6M. Short-term rental would be a non-conforming use. Short-term rental is defined in the Blowing Rock Code, section 16-10.12, as the rental, lease, or offer to make available any attached or detached residential dwelling unit or portion thereof by way of a rental agreement, lease, license, or any other means, whether oral or written, for compensation or consideration for a duration that is less than 28 consecutive days. Non-conforming use is defined as a non-conforming situation that occurs when property is used for a purpose or in a manner made unlawful by the use regulations applicable to the district in which the property is located. The Blowing Rock Code ordinance, which says what is required to be, in layman's terms, grandfathered, is section 16-8.1. Blowing Rock Code section 16-8.1 says continuation of non-conforming situations and completion of non-conforming projects, except as otherwise specifically provided in this chapter. Non-conforming situations that were otherwise lawful on the effective date of this chapter may be continued, subject to the restrictions and qualifications set forth in section 16-8.2 and 16-8.9. The property here has not been used for the non-conforming use of short-term rental since the date of enactment, August 13, 2019, of the Blowing Rock Code zoning ordinance, which made short-term rentals a non-conforming use, section 16-10.12. Yes.
Question.
Yeah.
You mentioned in the last paragraph that you were mentioning, you said 16-8.9. Is that what you said?
Yes, subject to the restrictions and qualifications set forth in section 16.8.2 and 16-8.9.
There's not 8.9.
What are we doing?
Here's a 3 right under that. Is that, if I've got that right?
I was trying to understand the context of the paragraph.
16-8.1, that's, let me find it.
And also 8.2 is talking about non-conforming lots. So maybe it's 8.6.
Okay, I'm reading section 16-8.1.
Yep.
Subject to the restrictions and qualifications set forth in section 16-8.2 and 16-8.9.
Yeah,
You say a 16-8.9 doesn't exist?
that's right. It's probably a typo.
Well,
I'm looking at it too. I see it there too.
okay.
I don't know what that's referring to.
Well, it's in the code book. We'll leave it in there. If it doesn't exist, then it doesn't have many restrictions and qualifications, I guess.
All right.
So let me go back. The property here has not been used for the non-conforming use of short-term rentals since the date of enactment, August 13, 2019, of the Blowing Rock Code zoning ordinance, which made short-term rentals a non-conforming use. That would be section 16-10.12, up until the date of this appeal, November 20th, 2025. Anyone want to add any facts? Any board member? Okay, all right. I make a motion that we accept the factual findings as just stated. Is there a second?
Second.
All in favor of accepting the factual findings as I've just narrated them, say aye. Aye, it's unanimous. I move that we close the evidentiary hearing at this time. Is there a second?
Second.
Seconded by Mr. Walker. All those in favor of closing the evidentiary hearing and moving to conclusions of law, say aye. Aye. It's unanimous. The applicable standards. In order for appellant to establish that the property at 439 Chestnut Drive, units A, B, C, D, Blowing Rock, North Carolina, should be allowed to have the legal non-conforming use of short-term rentals in its Blowing Rock R-6M zoning district, the appellant must show by substantial material and competent evidence that A, the property was being used for that use prior to the enactment of the Blowing Rock ordinance regulating short-term rentals on August 13th, 2019, and the use was otherwise lawful. See Blowing Rock Code Section 16-8.1. And B, the use continued and there was no consecutive period of 180 days where that non-conforming use has been discontinued. See Blowing Rock Code Section 16-8.6. Or the appellant must show a vested right to have short-term rentals has been legally established. See Blowing Rock Code Section 16-10.12.1. The conclusions of law, the appellant has not pursued a vested right argument that the property should be allowed to have non-conforming use of short-term rentals. Appellant has not produced evidence of a vested right, so the board finds no vested right for the property to be allowed the non-conforming use of short-term rentals. Turning now to whether or not appellant has produced substantial material or competent evidence that the legal and conforming use of short-term rentals had been taking place at the property prior to the enactment of the zoning amendment on August 13, 2019, which made short-term rentals a non-conforming use in zoning district R-6M. The appellant has not presented substantial material and competent evidence that the use of short-term rentals took place at the property prior to the zoning amendment on August 13, 2019. The appellant has not produced substantial material and competent evidence that after the town of Blowing Rock began regulating short-term rentals on August 13, 2019, under Blowing Rock Code Section 16-10.12, there have been short-term rentals of the property since that day, and there has been no consecutive period of 180 days where the non-conforming use of short-term rentals has been discontinued. Blowing Rock Code Section 16-8.6.3 provides that when a structure or operation made non-conforming by this chapter is vacant or discontinued at the effective date of this chapter, the 180-day period for purposes of this section begin to run at the effective date of this chapter. The town of Blowing Rock, through the Blowing Rock Planning Director, has produced substantial material and competent evidence that there has been a consecutive period of 180 days when the property has not been used for the non-conforming use of short-term rentals, that use having been discontinued, and the period of discontinuance has been from the effective date of the chapter making short-term rentals a non-conforming use in zoning district R6M, August 13th, 2019, up until the date of the appellant's appeal, November 20th, 2025, and continuing on to the present day. The evidence includes the appellant's strike that. The Board of Adjustment finds that the non-conforming use of short-term rentals was discontinued for a consecutive period of 180 days, and the property involved here is ordered by the Blowing Rock Board of Adjustment to hereafter be used only for conforming purposes. There has not been sufficient evidence from the appellant that the applicable standards have been met such that the non-conforming use of short-term rental should be grandfathered and allowed as a legal non-conforming use at the property of 439 Chestnut Drive, Units A, B, C, and D, Blowing Rock, North Carolina. After consideration of the evidence produced at this appeal hearing, the Blowing Rock Board of Adjustment finds that the Blowing Rock Planning Director was correct in his determination that the non-conforming use of short-term rentals is not allowed at 439 Chestnut Drive, Units A, B, C, and D, Blowing Rock, North Carolina. The appellant's appeal is not granted. The Board of Adjustment did adopt the above conclusions of law, and I make a motion that we adopt the conclusions of law as just stated. Is there a second?
Second.
Mr. Brandon seconds. All in favor of adopting the conclusions of law as I've just stated them, say aye.
Aye.
Aye. It is unanimous. So the Board of Adjustment did adopt the above conclusions of law by a unanimous vote, and the Board of Adjustment denies the appellant's appeal by a unanimous vote. This decision will be put into writing for approval by all of the participating members of the Blowing Rock Board of Adjustment. And this decision is effective upon filing with the clerk. Have I forgotten anything? I move that we conclude this meeting of the Blowing Rock Board of Adjustment. Is there a second? Seconded by Ms. Murphy. All in favor of concluding this meeting, say aye. Aye. Aye, it's unanimous. And everyone have a good evening and be careful of the ice.